politics and the law is a very adversarial thing. And I think one of the most important lessons that I learned was you got to put yourself in the other side's shoes a little bit. Walk around, see why they believe what they believe, why they think the way that they think. Another thing that I think I learned is that so much of what we do as lawyers really is a political process. Who you know in that system and who you're able to get advice and what resources you're able to tap to try to make your arguments better or to try to get input on a case or knowing a clerk of court. I think it's true that I've got as much help from court clerks and bailiffs and sheriff's deputies over the years in my law practice as I have from lawyers and judges and appellate judges or justices.
That was Lester Tate, former chair of the Georgia Judicial Qualifications Commission and former president of the State Bar of Georgia, speaking about the value of the intangibles as they have an impact upon successful law practice and the political nature of successful advocacy. Lester Tate joined me for about an hour to discuss his career and background, the state of judicial ethics in the present time, as well as those components that make for good lawyering. I hope that you enjoy listening to this podcast half as much as I enjoyed doing it, and I hope you learn half as much as I learned from Lester. This is the Advocates Key podcast. I'm Scott Key with Scott Key & Associates. You can find me at scottkeylaw.com. I'm joined by Lester Tate, the former president of the State Bar of Georgia, former chair of the JQC, very active in the legal community. Thanks for joining me on the podcast today.
Thank you so much for having me, Scott. It's a pleasure to be here and look forward to talking to you.
Well, take a minute. I always like to have guests introduce themselves. Who is Lester Tate?
Well, I'm a kid that grew up in Cedartown, Georgia. My dad worked at the Goodyear Mill there. As a kid, I think I liked these law shows and particularly liked watching Perry Mason reruns. So ultimately, went to Georgia Tech because my parents made two mistakes. Mistake number one was they thought if you were smart, you went to Georgia Tech, regardless of where your aptitudes lay, even if they weren't in engineering and sciences. And the second mistake they made was they thought I was smart. But somehow I managed to get out, as Tech graduates call graduation, and go to law school. And I've been practicing law in Cartersville for about 34 years now. And I will have to say that I really enjoy the practice and the life of really just being a country lawyer.
And you practice and live now pretty much close to where you grew up. You grew up in Cedartown, I think.
Yeah, I ended up in Cartersville. I practiced law in Atlanta for about 3 years right after I got out of law school. And one of the great things about Cartersville, Georgia, I know you didn't have me on to be the tourism czar for Cartersville, but Cartersville is a great place to live and work. And I feel like I've got, when I went to Georgia Tech, I really kind of fell in love with Atlanta. I like Atlanta. I like the city, but I like the small town too. And Cartersville is sort of a perfect blend of both of those because I'm only 40 minutes from downtown. When I could be to the center of downtown. When I was the state bar president, I could go to bar headquarters down on Marietta Street in 50 minutes. Which is about what you would expect coming from Alpharetta or some of those places now. But I still get a lot of small town life, and I get to have a sort of small town practice, and I really enjoy both of those.
Yeah, that's kind of what Griffin's like. I'm in Griffin, practicing McDonough, and it's about this. Depending upon what might happen with Eagles Landing Parkway, Hudson Bridge Road, it's about that equivalent distance to come into Atlanta if I have to go to the Supreme Court or Court of Appeals or go to the State Bar or something like that. So, yeah, definitely small town, particularly if you can be that close to Atlanta, is the way to go.
Well, and I think, too, it was always sort of my desire to have a statewide practice. So in better times when we weren't in the middle of COVID and things like that, I was in Atlanta 3 or 4 days a week. So you can have, as my friend and mentor Bobby Lee Cook said, you can have as good a practice in a small town at Georgia as you can in Atlanta or New York City because we read the same books, is what he said. I guess I'd say we have the same computers nowadays because books seem a bit passé. But it really is the quality of the practice that you have and not the geographical location, I think.
Well, there was a period of time, just looking at doing a little bit of research on you, there was a period of time where you were in D.C.
Yes, there was, and I really enjoyed it. It's still one of the most formative things that I did. Graduating from Georgia Tech and wanting to get into law school, my grades having suffered from having to take calculus and chemistry, and I think chemistry is the only class I ever flunked, just made a flat F in. But I wanted to make myself attractive to law school, so I applied for an internship at the General Assembly and for an internship with Senator Nunn, and I got both of those. So I graduated from Georgia Tech. I did the internship at the General Assembly. I did the internship with Senator Nunn, and Nunn's office offered me a job. But at the end of sort of at the end of that time, the KAL 007 got shot down over the Sea of Japan. That. Larry McDonough, who was the most conservative member of Congress, but he was also a Democrat because everybody in Georgia was a Democrat at that point. And he was on that plane and was killed. And so somebody that I knew a little more distantly then was George Buddy Darden, who had been district attorney in Cobb County. He was in the state legislature. He ran and got elected to that congressional seat and hired me, 21 years old, to be his press secretary. It was one of the best jobs I've ever had. It's really the only job I've ever had other than being a trial lawyer. And so Buddy became my mentor. And of course, he served, I think, 12, 13 years in Congress, came back, has practiced law, and he's still my mentor today. He just had his 77th birthday, I think. I talk to him about 2 or 3 times a week, or we're always off to a fundraiser or a bar meeting or a political event, through the week. But that was some of the most formative times in my life. And I felt like there are a lot of people who want to go clerk for a judge to sort of get a little practical experience and be able to observe other people after they complete their law degree. But I felt like I got a full, 3-year clerkship under Buddy's tutelage. And it's the kind of thing that really and truly has helped me more than anything else in my career.
And this was before law school that you did that?
It was, I guess I've always been a believer in momentum. Because when I went to Tech, I actually went summers. I had an apartment. I thought I just want to get through. So I got through Tech in 3 years. And then I worked in Washington for about 3 years and went to law school at the University of South Carolina. And I actually went through law school in 2.5 years. So I sort of accelerated both of those. And I was able to get out and sort of start practicing at the normal age that you would be if you'd went straight through. But I kind of had that 3 years of experience. And, frankly, I think I learned more during that interregnum than I did at Georgia Tech or in law school about things that I just use day to day, in my law practice.
Well, what were some of the lessons from the job of being a press secretary then that you take with you into law school? What are some things that you kind of do or you think you excel at as a result of the experience of being a congressional press secretary?
I think one of the first things that I think I learned from Buddy Darden was that you always, now this is sometimes called the Atticus Finch lesson. In To Kill a Mockingbird, he says you never really understand somebody until you get in their shoes and walk around in their shoes, a little bit. And, politics and the law is a very adversarial thing. And I think one of the most important lessons that I learned was you got to put yourself in the other side's shoes a little bit, walk around, see why they believe what they believe, why they think the way that they think. Another thing that I think I learned is that so much of what we do as lawyers really is a political process. And by that, I mean that political in the highest use of that word, not in the pejorative use of that word. But, if you think about it, we've got 3 branches of government. And the judicial branch, where court cases are heard, is the only branch of government that you get to pick the person that goes to represent you, hands down, no real question about it, unless you're in a court-appointed situation. But who in that system and who you're able to get advice and what resources you're able to tap to try to make your arguments better or to try to get input on a case. Or knowing a clerk of court, that will...
It's so important to know the clerk of court.
It's just it. And so in the political realm, you learn how it's sort of the richest man in the graveyard, is equal to the poorest man in the graveyard, at the end of the day. That's true at the ballot box, too. And I think it's true that I've gotten a lot more help as much help from court clerks and bailiffs and sheriff's deputies over the years in my law practice as I have from lawyers and judges and appellate judges or justices.
Giving an opening and a closing and knowing the rules of evidence and knowing how to cross and, do a theme of all of the litigation trial skills are very important, but they're such a small percentage of the job.
It really is. There was when you're the bar president, people want you to come give them a speech, particularly a lot of younger lawyers. I don't really know that I have a lot of wisdom to impart, but one of the sort of speeches that I regularly gave to younger lawyers, and a couple of the groups asked me back, so they must have thought I knew something, even if I didn't. But one of the things that I would tell them is I think there are three basic skills, certainly for trial lawyers. And one of those is that you have got to be a scholar. Because if you don't know what the law is, and if you think you're going to just BS your way and bluff your way through without knowing what the law is and without being able to come up with novel legal theories or novel legal defenses or whatever else, you're not going to be much of a lawyer. You have to know the law. You have to be a legal scholar. Second thing, I think, is that what you've just talked about, those skills that are courtroom skills, to be able to go out and cross-examine a witness, to be able to make a decision when something favorable or unfavorable happens in a courtroom, to either press the advantage or to get out of an ambush. You have to know that. The third skill that I've said is really that of being a politician, of being able to network, to have people that will help and support you, people you can reach out to and get advice from, people that can do a favor for you, and I mean an appropriate favor, not ruling for you because they're your friend, and to bring you business. Because, private practice of law is supposed to be a profitable enterprise. We did this because we want to help people, but we want to make a living just like a carpenter or a truck driver or a doctor or a stockbroker does. Mm-hmm. And so what I concluded was that of those three skills, if you have any two of those, you'll do all right. Maybe if you don't know the law that much, but you're good in court and you got a lot of friends, you'll do all right. Or maybe if you're really smart and you're not very good in court, but you know a lot of folks, you will. But if you want to be a great lawyer, you really have to do all three of those, and you have to do all three of those pretty well, I think.
Mm-hmm. It's like all the tools you need to be a good baseball player. It's the same kind of thing.
Exactly. In fact, that's sort of where I got the idea from, was that baseball players talk about a 5-tool play, which is, I think it's speed, hit for power, field, and hit for average, I think. Mm-hmm. And so I think it's a very, very similar thing with lawyers, that you've got all these different components or vectors that you have to sort of hit on it, for all times. Now, that may not be true if you're a real estate lawyer or if you're a municipal bond lawyer or something, but it's certainly true to be a trial lawyer.
And have you practiced, or has your home office been, or your main office been in Cartersville your whole career?
No, when I was in law school, I clerked for Smith, Gambrell and Russell, and for a smaller firm, Savell and Williams, and I got job offers from both of those. I took the job offer with a smaller firm because I felt like it would enable me to get into the courtroom sooner. Mm-hmm. And then that firm sort of split into Goodman McGuffey, Austin, Lindsay at the time. And I was one of the original 5 lawyers that went with them when they left the other firm. But I kind of told them, I said, I really want to practice law back probably closer to home and in a little bit different setting. And so I'm happy to go with you, but I'm not sure I want to keep doing that year after year. So I was with them about a year, and I had a pretty good client that liked me, who was the power company, and they were building a big dam up in Rome, and it was the largest construction project east of the Mississippi. And I was basically defending them in tort cases and workers' comp cases. I decided it was probably a pretty good time if I wanted to go hang out a shingle to do it. And so I left Atlanta, came to Cartersville. I went to my now partner, Morgan Akin, his family had been practicing law up here for a long period of time. And he rented me an office for $328 a month, I remember. And I had a part-time secretary. So I hung out a shingle. And he gave me this upstairs office. It's on the public square. It had built-in bookcases. And Scott, it was about the time that John Grisham's a time to kill.
I was just thinking about a time to kill when you were describing your office.
Yeah. And so, I went up there and he said, well, I got this office up here. Let me take you up here. So I felt like I was Jake Brigance going up the stairs to the Will Banks law firm, to get and I saw the place and felt like I had immediately sort of found my home. And so for about 5 years, I was just a solo practitioner up there, did court-appointed state criminal work, court-appointed federal criminal work, had a few retained cases there, did plaintiff's personal injury, did divorces. I've jury tried about 100 cases, and I think 3 or 4 of those have been divorce cases that I tried. I defended the power company. So I had just about every case, you could kind of imagine. And the Akin firm had been there since 1836. It's the oldest ongoing law firm in the state of Georgia. And so Morgan sort of got after me just to merge our practices, and we did that in 1996. Really now he's semi-retired, so somehow without ever having a lawyer in the family, I've managed to inherit the oldest law firm in the state of Georgia and continue to do a lot of those things, although not divorces, unless it's something particularly odd or interesting,
Yeah, I'll only do those at the appellate level. I don't generally, as a rule, do those at the trial level, so I can understand why you wouldn't want to do that. So I guess that would make Mr. Akin your Lucien Wilbanks then.
He would, yes. He hasn't been disbarred, but I'll tell you, and going back to sort of one of the things you were asking me about earlier about geography, Morgan is retired, semi-retired now. He only comes in a couple of days a week, so it's really basically my show, now that's going on. But Morgan was a 4th-generation lawyer, and he got accepted to Harvard Law School. He turned Harvard Law School down because the University of Georgia not only accepted him, but they gave him a full scholarship where they paid him tuition, room, board, and a stipend. And he wanted to practice law in Georgia. Harvard wasn't going to pay for him to go there. They were going to charge him the full freight. So he decided to go to Georgia, graduated 2nd or 3rd in his class, came back to Cartersville. So there is a high caliber to the bar, in my view, as high caliber as there are in just about any big firm that you wanted to go to, in the state of Georgia or for that matter, New York. And we've always tried to hold ourselves to the higher standards.
Now, I know that there was a period of time where I know that you were the state bar president several years ago. And then I think, was it after that you were the chair of the JQC?
I was on the JQC. I got on the JQC at the end of my bar presidency. I think they overlapped about 6 months, and then I eventually became the chairman of Judicial Qualifications up until when the legislature wanted to politicize that. I did not want to be a part of that, and so I decided to leave at that point. It's kind of funny. I was the chair of and for your listeners, Judicial Qualifications Commission is the oversees judicial ethics and judicial discipline for judges. And I went to one meeting as my last meeting I chaired, and I left and had a judge who an issue arose in between. And I think I actually went back to the next meeting representing the judge. And I have to tell you, and I think this is one of the big things that maybe younger lawyers confront. Some folks are very comfortable, thankfully, and I admire these folks, are very comfortable sort of sitting in judgment, of other people and, making decisions. And we need people to do that. So they have my highest commendation. But I think I realized that I never, that probably wasn't what was cut out for me. I'm an advocate, and that's just sort of the way I was born. And I felt more at ease sitting at the other end of the table representing the judge than I ever did being the chair of a commission of inquest,
But you were chair of the JQC, or at least I think maybe this started before you were the chair. I distinctly recall, a period of time back around 15, 16, right around in there where probably the JQC was more active in Georgia than I've known it to be since, and that I've heard that it was before. I mean, it was a pretty active group at the time.
It was very active, and it was very active. It's one reason I accepted the Board of Governors election of me to that body was because I felt like it was very active, and I felt like they were doing some good work, albeit everybody like that makes mistakes and has growing pains. And what a lot of people don't realize about the Judicial Qualifications Commission, that most agencies or bodies that have initials, have a lot of resources. Mm-hmm. The FBI, the CIA, the GBI, have a lot of resources. But the Judicial Qualifications Commission was created by the Georgia Constitution. I think it was the 83 Constitution. And we had one full-time administrative person at the time I was there, and, would contract out for investigation. But we didn't have a lot of resources to devote to stuff. So there were a lot of sort of growing pains with it. But I think what happened to our Judicial Qualifications Commission, and really one of the reasons I was not interested in remaining the chair, is that the legislature got involved with it. And the legislature, whereas before you had 3 members that were elected by the bar, and you had the Supreme Court had appointed 2, and then you had a lay person that was appointed by the governor. I think 2 lay people that were appointed by the governor. Well, the legislature wanted to take over all those and exert political influence over a body that's supposed to be neutral and sitting in judgment of the conduct of judges. Judges are some of the most powerful people, and particularly individual judges in different counties. I remember when I was bar president, I went down to Albany to give a speech one time, and I was talking to a former Superior Court judge, and he was talking about the late, great George T. Smith. I don't know if you remember George T. Smith.
I'm familiar with the name, but he's a little before me.
He served in every branch of government. He was in the legislature. He was on the Supreme Court ultimately, and he was the lieutenant governor at one time too. So anyway, George T. Smith had passed away, and this judge said to me, and I'm telling you this because I think it's indicative of the power of Superior Court judges. He said, well, I went bird hunting with Justice Smith, and I called him Justice Smith, and he says, don't call me Justice Smith. Said, I'm just George T. And the judge said, you're a very important judicial official. You're on the highest court in the state. And he said, listen, I'm not important. They had, 7 members at that time. So it took 4, to be in the majority. And he said, I'm not important. He said, in a divorce case, you can take a man's kids away from him. You can take his house away from him. Criminal case, you can send him to the penitentiary. You can send him to be executed, in some instances. He says, hell, I got to get 3 other jackasses to go along with me. And I think that really does speak to the fact that, when you talk about judicial discipline and what's going on out there, you've got a group of people who have wide authority to do a lot of different things. And there's no group of people anywhere that I really believe need to have unfettered authority. And I think the JQC conducted a lot of investigations and did a lot of things that were helpful towards making sure that power was exercised properly instead of improperly. And you don't see as much of that now because it's been politicized.
Well, I think even beyond the ethical component of what the JQC did in that era, I think in large part the JQC's work in that time modernized the Georgia bench, because I think there was an element of quality control to what happened. You can go into, there's one circuit in particular where I practice frequently where I feel like it's a modern court system, and when I first started practicing in this particular circuit, it wasn't. You mentioned in a statement you gave to the press, I think maybe toward the end of your tenure with JQC, if you go into court now and the judge doesn't even consider your side, the judge violates the rules of ethics. You need to have a place that will judge the judge. In the past 8 years, the commission has removed more than 60 judges from the bench. I think that you can't overstate the value of having an independent commission that will look into these citizen complaints. And so really, I mean, you take a process that removes 60 judges over a fairly short period of years. I don't know that there's ever been a time in Georgia history where there was that level of activity with judicial ethics.
No, I agree with that. And I still believe, what I said back then. It's funny. I was actually in court yesterday for the first time, actually live in court like it used to be since the pandemic has struck. And the judge, as we're getting ready to go on the record and all this, and he was talking about COVID precautions. He goes, now, I don't want to get in trouble, with the JQC. And he said it sort of jokingly, and he wasn't doing anything wrong. There was nothing there. But my point is that I think because of what happened before, that it certainly made judges realize that there's somebody out there watching, and people who exercise vast power, I think, do need to know that there's somebody watching, when they take particular steps.
Well, it's disheartening as an advocate. Or it used to be. There was one judge that I would appear in front of that was removed during that period of time.
Right.
And I would, your client who hires you puts a great deal of trust into you, and you work really, both sides ideally work very hard to put on their case. And, I remember this particular judge, I was in front of him. It was an motions hearing, and I had an expert on the stand, and we had prepped that expert, and the family was there, and we were, we put a lot into our case. And I remember this judge, and I wasn't doing anything, I was being very professional and, prepared. And I remember this judge had a big high back chair up on the bench. And while I was questioning my expert, the judge swiveled his chair around and turned his back to us for the whole witness's examination. And then swiveled his chair back at one point when his secretary brought him a Coke, and he popped the Coke open and started drinking it up there on the
right.
And I don't expect that the judge is going to be in suspense, and I'm sure judges kind of often know what they're going to do when they go out on the bench and make their mind up, but there is an element of, just like we owe the bench professionalism, we're owed professionalism as advocates and the clients. Whether it be, if your client is a power company or if your client is an indigent criminal defendant, is owed some level of respect.
I think that's absolutely true. Your day in court means something. Supposed to mean something. And I've heard it said that every lawyer, when he hits the courthouse steps to go in and try his case, every lawyer thinks he's got a winner. But every judge, no judge should really have their mind made up about any case when they hit the courthouse step. They're supposed to go in there and at least sort of hear you out. It's one of the things that in a peculiar way bothers me when I look at the federal judicial confirmation things, and when they talk about, we're confirming a lot of people who haven't said a whole lot about particular areas, and, but that's in fact become a sort of model if you want to go on the federal bench. Don't say anything about anything that's controversial because, we're going to know what your views are. Well, really and truly, what you want is not people that haven't said what they think, but people who are not willing to let their prior thinking interfere with what decision they reach based on the evidence once they get in the courtroom. I think that is such an American value, and I'm sure in your case, Scott, how do you explain that? You and I are supposed to be advocates for our system, and I do believe it's like democracy. It's the greatest system except it's the worst system except for all others. There's problems with all of it. But, how do you go back and explain to that family, well, this is a great system, but the judge, I know he turned his back on us, didn't listen to us and anything else. But, you got your day in court. It just doesn't work.
Turned to my opposing counsel after I'd finished my closing and said, do you want to argue?
Horrible.
Right.
Horrible.
So, that's, and that's a very tough.
Yeah.
You should be able to, that's the beauty of our system when it works well. And if there's been one branch of government, without getting too political here, that it's worked very well in the past, month and a half, it's been the judicial branch. And what's amazing about it is I've been following all this election litigation, and it's the branch that it doesn't matter who appointed the judge. It doesn't matter who confirmed the judge. A lot of these cases are appearing in front of people who were appointed by the president bringing the case, or people on behalf of the president. And what you get is not only a clear decision, but you get in writing an explanation of how that decision was reached. And ideally, even when you lose, you should be able to tell your client, okay, here's why you lost. Here's what the judge thought. And I think when the system works, it works like that.
Yeah, and I think too, and I'm interested sort of in your view on this, Scott. And I'm not trying to be overly political here, but the Trump folks are the ones that have gone 0 for 38 or 40 wherever we are right now. Some people are sort of outraged that, well, this is a judge that President Trump appointed. Why is he ruling against President Trump? And to me, this idea the public has this idea, a wrong-headed idea, I would add, that because somebody appoints you, you're going to rule that way. So that's why we want to elect this president, whether it's Biden or Trump or whatever. They're going to appoint judges that are going to rule my way. And that's just not the way it's supposed to work, and it's not the way it works. And, these folks that you got as good a shot at getting a fair shake out of a Trump judge as you do an Obama judge or a Jimmy Carter judge. There's maybe still one or two of those around, or a Biden judge in the next administration. It's supposed to be the only branch of government where might does not make right. It's not politically picked.
If there's one thing that has kept me from just completely losing my mind watching the news in the past month and a half, it's been the way the judicial process has stepped up.
Yeah, I think I have to say, I think the rule of law is standing pretty tall, right now. And, I disclose, well, I don't know that I said political parties, but, I started out working for Democrats. So I've been chairman of a local Democratic Party. I got lots of Republican friends, and I'm not so, there are a lot of things that Republicans have done over the years that I fully supported and others that didn't. I try to look at the issue, as opposed to anything else. But you got to look at our Secretary of State, who's a Republican, our governor, who's a Republican, that I probably, have a lot of political differences with, and certainly not on their campaign teams or anything else. But they've displayed, in my view, tremendous respect for the rule of law. The governor's having to tell folks, I can't just call a session of the legislature to overturn the will of the people. And it's what's discouraging about that is that a governor even has to explain that, to somebody. But it's there nonetheless.
What do you think about? And I don't want to put you in a position where you're commenting on any particular person, but what do you think about the way? I know that when you stepped down from JQC, and I'm looking at your letter, and what you said about what was happening to JQC at the time was what we've seen here is legislators that have come forward and just said point blank to folks, we don't like the way you've treated judges that we like, and for that reason we're going to abolish you. A system that only disciplines judges who are politically unpopular and does absolutely nothing to judges who are popular isn't a very fair system. What do you think about? I mean, I do think that there's been a tremendous amount of momentum, and I do think the judiciary is, as a whole, better for the work that the JQC did in that period of time. What do you think about judicial ethics, or the process of, I guess, adjudicating judicial ethics complaints in the time since the legislature did what it did to it?
Well, I think what's going on is not the prosecutions that you see brought, but the ones that you see that are not brought, And there's no doubt but that has fallen off since we left. And one of the other things that I said in that letter that I think I have to highlight in answering your question is you had the governor's office sort of messing in who they were appointing. We had an investigator that we were about to get rid of, and the governor's office appoints him to the commission. You had legislators who were upset because their judges, who were elected officials, came and complained to them about the JQC. You even had, and I think if you know anything about me, I try to sort of shoot straight and tell you the true facts here. Even the Georgia Supreme Court, we issued an opinion. There's a case out of DeKalb County, went all the way to the U.S. Supreme Court, that says you got to have open courts. We were getting complaints from all over the state about, just like you're talking about the family of your client being there, where somebody had driven all across the state to be with their loved one or family member at a time they had to appear in court, and the courtroom's closed. Well, the U.S. Supreme Court said open courts, you got to have open courts. When I was on Judicial Qualifications Judicial Qualifications, we wanted to just sort of, I'll say, tap judges on the shoulder and remind them of this opinion. So we put out an advisory opinion that said courts have to be open, and if you're not keeping your court open, you're violating the law. We received from the First Amendment Foundation in Georgia their annual award. We had a banquet, dinner, where most of the Supreme Court, a majority of the Georgia Supreme Court came and feted us for issuing this opinion, just reminding judges, you've got to keep the courtroom open to the public. Later, a judge who was sort of unhappy with it, he writes a letter, kid you not, to the Chief Justice, and they decide they want to just suddenly review. I've never known the Georgia Supreme Court to review something based on a letter before, but they decide, we're going to review this. And then in this about, 50-page opinion, the Georgia Supreme Court essentially, and they made it, as I recall, per curiam, which meant that none of them had to really put their name to it, although I'm pretty sure I know who wrote it. Overturning this advisory opinion that we put out for the sole purpose of just trying to make sure that people had access to the courts. Now, I tell you that to say that whether it's the Georgia Supreme Court, whether it's the Georgia legislature, whether it's the governor, there are powerful forces at work to try to protect people within their purview, people that come and complain to them. I'm not talking about anything other than, I've had complaints from these people. These are people I like, so I want to change the system and influence the system for them. I think the founding fathers, who did not create the JQC, but created a much more intricate government, saw that self-interest is always going to be there. Self-interest is always going to be there. The reason the Supreme Court did what they did with this opinion that they had gone and celebrated us was because some of the judges complained about it to them. That's what happened. I know exactly what happened in that case. But my point is that all those conflicting interests, there's supposed to be checks and balances on that. And we had a check and balance on that, which was that the Georgia Constitution said that the Board of Governors, State Bar of Georgia, put 3 lawyers on there. 3 lawyers who, in my experience, actually knew more about what went on in courtrooms across the state than judges. Funny thing, judges never go in other judges' courtrooms.
Right. Yeah, we see it all.
Yeah. And, in fact, when I was on the commission and we had judges on there, one of the judges on the commission might say, well, I would never do that. And the lawyers would say, well, every other judge in the state does it this way. So there are powerful interests at work, sort of both ways. And I felt like that we had a pretty good balance with that. The fact that some people didn't like it probably means we were doing our job,
right,
a little bit. And so the system that we have right now is, I don't think, anywhere near as effective at that. And interestingly, too, with a COVID situation, you now have in some of these orders that the Supreme Court has put out since then, they're telling judges, now if you don't do what we say, you could be subject to judicial sanction, all of which is fine. But, no less important than COVID was the issue of open courts, and they didn't want to interfere with that,
Right.
So it's often a question of politics.
Well, there's also, I feel like with the COVID stuff, it kind of reveals just how there isn't really a centralized system or uniform system of what you're supposed to do. Because for the most part, I've been doing court via some sort of video conferencing, whether it be WebEx or Zoom. But then there are some of these outlying counties that just insist still that you come in for pretty routine things that you don't really need to be herded into a room to do.
Right.
And I know that there were a couple of judges that were, even during at the height of the emergency order, that were trying to send out jury notices and stuff like that. So it does just seem like it's a little too decentralized. And I don't know if it's just the COVID thing or if just the COVID protocols or lack thereof, if it just highlights the lack of a centralized, uniform way to handle things.
I think it does. And I think in some instances too, I don't think that in some of the rural counties and whatnot, the judges don't have, I'm not being critical of them because I don't think they have the resources to employ to actually, like go employ an epidemiologist and find out, could we run a jury trial this way or whatever. I mean, that's one of the reasons we have various levels of government. The county commissioner is not going to be able to protect you if Spalding County gets invaded. We've got the federal government for that. By the same token, President Trump's not going to give you a variance to, build a hog farm, in Spalding County. So, there are different levels of government have different resources. But I think in a lot of ways, the Superior Court judges and the state court judges out there trying to have trials, trying to get back to normal, I'm not sure they have the resources, the input, to make the plans that they need to plan, that they need to do that. And that's unfortunate, but, the state does have to have sort of a role in that, I think.
Well, particularly, it's one thing to make us, the lawyers, come in for certain things, or to make the summons the client in. But I think it's a whole other level when you start forcing penalty of going to jail or being charged with a crime or being held in contempt, when you start forcing members of the public to come in to be packed into a court in the middle of a pandemic to serve on juries.
Yeah, I will tell you that one of the things that I've and I want to say too, I want to give Justice Melton and the court pretty high marks for what they've done, with trying to get instructions out there for the judicial orders that they got out there. So I'm talking issues and not personalities.
Right.
The Supreme Court and the Court of Appeals are still doing Zoom arguments.
Right.
And they want to tell jurors that they've got to actually show up. I think that's not going to sit well with some members of the public to tell them, you've got to show up. You need to come down here and hear this case. But we're going to do ours via Zoom while we're sitting at home, and we're at no risk.
Mm-hmm.
So I think one of the other issues that we've got to look at, I've been a little bit shocked that not more lawyers are interested in looking at having trials via Zoom, WebEx, that kind of thing. My observation is the people who are generally against it are criminal defense lawyers, of which I do a fair amount of criminal defense. So I understand that. You want somebody there that has compassion for your client. And also civil defense lawyers, and I'm a plaintiff's lawyer for the most part, so I'm litigating against those. But I think the natural momentum there is criminal defense lawyers and civil defense lawyers are trying to preserve the status quo. My client's not in jail, and I don't want him to go to jail. My client's not had to pay any money in the civil sense, and I don't want them to have to pay any money.
Right.
But I think that I think we probably have people that are smart enough they could figure out a way to do some virtual trials in certain sort of cases and maybe making some accommodations one way or another. For example, in the civil arena, and I guess in the criminal arena too, would you have a Zoom trial if you knew your client wasn't going to go to the penitentiary? Would you have a Zoom trial if you were a defendant, if you knew the insurance company was not going to have to was going to be able to only have a verdict, have a high-low agreement where their verdict was only within the policy limit.
If you can lower the stakes, in other words, if there's no...
Yes, if you can lower the stakes and find out what's going on. But the alternative to that I see most proposed is, do you want to have a bench trial? And I don't know of any area other than divorce cases that bench trials have flourished, and I really think that having public input in the form of a jury is so important, as opposed to just all, we can't have a jury trial, so we need you to go do a bench trial. There ought to be some alternative to that still gets that public input.
If everybody could potentially agree that these are the parameters and these are the terms, where you could make it work for everybody to sort of make some agreements to have a jury trial over Zoom, I think it could work. And I hope first of all, I hope this pandemic is over as soon as it can possibly be over.
Yes.
But I tell you, there's a lot that I think we can take from this. That I hope that when this is over, we don't go back to a system where we have to wake up at 5 a.m. to drive 4 counties away,
right,
so that we can say ready for trial, judge, and then leave.
Right. The calendar call, I hope, goes the way of the dinosaur. And, they used to, this was before I started practicing, but I am told at one time in Bartow County that they'd have a criminal trial week, and every person accused of a crime had to appear.
Mm-hmm.
And their lawyer had to appear. So they would start a trial, and they would keep everybody else sitting there waiting in case that case, pled out or whatever, and they needed another trial. And then they got where they'd stop the trial and they'd have a calendar call. If somebody wasn't there, they'd issue a bench warrant.
Mm-hmm.
And then they'd be in jail and, we'll let you out if you'll plead guilty,
right,
kind of thing. And that's sort of the dirty history of calendar calls and, you've got to appear and, that kind of thing. I think one of the reasons they wanted to do calendar calls in criminal cases so they'd make sure the defendant hadn't skipped bail, and gone off someplace. But even that's more rare now, I think, just because of cell phones. Everybody's got a cell phone, cars,
mm-hmm,
license plate readers. There's not very many people that are skipping out not to be heard from again.
Mm-hmm.
So it'll be interesting to see if that does in fact die.
Well, changing gears kind of completely. So suppose that I've got a listener who is just getting started practicing law, like maybe it's just started their office. They're kind of where you were when you got shown your upstairs office on the Cartersville Square, and they're wanting to get into some personal injury litigation. They want to,
Sure.
they want to break into that and figure it out. What advice do you give to, a lawyer in that situation? That's a very broad question, I know.
It is, but the first thing that comes to my mind is that you need to get out in the community, and you need to get out, get involved in the community to the extent that if they were running for Congress, they'd be out going to events and talking to people, and that kind of thing. They'd be going to party events, or party caucuses and stuff like that. And so for a trial lawyer that wanted to do that, I think unless you've got a lot of money and you want to get in the high-end advertising, billboard, TV business, you're looking for a referral practice. And so what you want to do is reach out to business and community leaders and to get them to send you business and to have confidence in you and to have confidence in your judgment. So I remember when I was at that stage, I was at some Chamber of Commerce picnic or something, and there was a bunch of politicians there. Somebody said, "What are you running for?" And I said, "I'm running to be your lawyer." That's what I'm running for. And I think also to hit the other themes that I talked about with regard to, there are groups like Georgia Trial Lawyers Association, which I'm a member of, Georgia Criminal Defense Lawyers, which I think you were president of.
I was, yeah.
Those organizations provide tremendous support to people who are in those organizations. I'm talking about support in the form of seminars, resources to find out, get other people's briefs, other orders that judges have issued, those kinds of things, and to train you to really be a good lawyer, as well as getting referrals. I mean, I get 3 or 4 calls a week from somebody that needs a lawyer someplace. And, it's not always the kind of case I handle or whatever, but I think getting involved both in your community, whatever community you want to hang out a shingle in, and in your profession, be it through the State Bar or GTLA, Georgia Association of Criminal Defense Lawyers, those groups, that's the way to go. Treat
it like you're running for office, and then use your professional organization to learn how to do the case and to get the referrals from there as well.
Yes. And then one other thing I would say is get a good mentor. And I'm going back again to what I said about Buddy Darden, but he was the kind of guy I could call. I could pick up the phone and call, and he'd either, if he knew, he'd tell me, but if not, he could tell me somebody else that could help me with that particular situation, that case, give me some advice on it, that kind of thing.
Well, and I also know that one of the areas of law that you handle is you actually represent your fair number of lawyers. You do some attorney discipline cases where you defend.
I do. I never set out for this to happen, but I somehow got the trifecta of lawyer and judicial discipline because I chaired the investigative panel, which is one end of the bar's grievance proceeding. I chaired the Judicial Qualifications Commission. I never chaired the review panel, which is sort of the other end of the bars, but I did serve on the review panel, so I served on all 3 of those. And I like lawyers. I like representing lawyers. I've represented lawyers in a lot of different situations. Not all of them are bar grievances. I was in court yesterday representing a lawyer that another lawyer was trying to claim, attorney's fees against and that kind of thing. So done a lot of that. And I've represented a lot of judges too. I'm proud to say I've had a lot of judges that have come to me that I've been able to help. I really like doing that because in the environment that we're in right now, lawyers and judges become targets very easily. For people who are unhappy with the outcome of a case.
What are the patterns? Like, what are if there were cautionary tales, and I'm not trying to get into anything privileged, but if there were just sort of themes or lessons that you have taken from representing judges and representing lawyers, what sorts of things do you see that sort of maybe brought people? I can speak of this from criminal defense. I kind of and I guess probably even in the civil process, a lot of my clients are not bad. If there were a crime called poor judgment, that's really what it kind of falls under. What are some of the themes or some of the issues that you see that arise that sort of get those cases, get people in trouble?
Lack of objectivity, I think, is one of the top ones. That's particularly true for judges, where you let your emotions get in and sort of take control. And a lot of the cases I had with judges involved, they've got some lawyer that's sort of semi-misbehaving in front of them, or they're irritated or whatever, and they kind of fly off the handle, and it blows up in their face, even though they didn't start it. I see a lot of lawyers that they get that, every lawyer I know has had that one or two case in their career that they just really let get under their skin, and it was sometimes who the opponent was, sometimes who your client was that you cared that much for them. But you got to the point where you were taking everything personally. It was all personal. And it pushes you toward this win at all cost sort of situation. And so I think that's one of the biggest things. I think sole practitioners get in trouble more because a lot of times they don't avail themselves of a mentor or of their colleagues in GACTL or GTLA or the state bar to try to bounce things off of, because we all have bad ideas too, and I hope I've got enough sense when I have a bad idea to at least, maybe I'll get on the phone to Scott and say, Scott, what do you think about this? You say, Lester, that's a terrible idea. Don't do that. You're going to get in trouble. And so I think that's one thing. We do see a lot of, I will say too, the number one cause of disbarment still is not keeping your trust account business separate, or lawyers that take from their trust account or whatnot. And most of those lawyers are lawyers who have they've already gotten into trouble. They're compounding the trouble at that point. They're either, they have substance abuse problems, they have psychological problems, sometimes depression, they hadn't tended their business, whatever else. They've let their lifestyle really, they've over leveraged themselves, and as a result of that, they let the financial concerns overcome what they know to be the ethical rules and that kind of thing. But I think those are generally speaking, that's the kind of stuff we see.
Well, how have you kept it together so well all these years? I mean, you've done some pretty high stakes things and been chair of JQC, and I see you're pretty active on Twitter and all of that. And I know that you're pretty heavily involved in, I know, like at least with the Democratic Party in your area.
Yeah.
How do you keep sane in all of this?
I don't believe those folks who say I enjoy my job so much I've never not wanted to get up and go to work. Because that's generally speaking, that's just not true. I have a very vivid memory of being in the middle of defending a client in a drive-by shooting case with a judge that was pretty hostile to us. And I took my kid was in elementary school, took him to elementary school, and I'm driving back to go to the courthouse for about the third day of this trial. And I see these guys at the dairy farm going out in the pouring rain to feed the cows, carrying bales of hay. And I vividly remember thinking, I wish I were doing that instead of going down to the courthouse today.
Because they're going to go home and they're not thinking about those cows.
Well, that's exactly right. That's exactly right. So that's my caveat.
Right.
That's my caveat. But I love what I do. And I feel like that one of the things that I've sort of strived for in my life is to integrate it. And if you think about the word integrity, it means integrated, that you're the same person, all the time. And so I get accused a lot, Lester, you don't take a vacation, you're always going to a bar meeting. Well, I've gone a lot of fun places, for bar meetings over the years. I've met a lot of people that I enjoy spending time with. I've gone on CLE, continuing legal education things down to the tropics, several years. I've been to multiple states all over. Next year I'll be the president of the Southeast American Board of Trial Advocates, chapter. So I've traveled a lot with them. I like what I do. I like representing people. I like going to court. Yesterday I got to go to court, like I said, for the first time, and to cross-examine a live witness for the first time in, 6 months. I've done it over Zoom, but I just hadn't done it in court in a long time. So I like what I do, and I think liking what I do is kind of what's kept me going. I don't really want to retire. I want to, my friend and mentor Bobby Lee Cook's 93, I think, and still going to the office. And, if the good Lord lets me hang around that long, I hope I'm still doing that too, because I like what I do. Don't love it every day, but on average, I'll say 28 days out of 30, I like it.
Oh, well, that's great. That's fantastic. Well, I really appreciate you taking some time out of your day to talk to me on this fledgling podcast of mine. I've really enjoyed it.
Well, I have too, Scott, and thank you. You're a great lawyer, and you're a credit to our profession. And doing things like being president of Georgia Association of Criminal Defense Lawyers, which I think is just an outstanding organization, not just for our profession, but for the public at large too, because you're you're standing between people's liberty and the awesome power of the state or federal government. But thank you for doing that. Thank you for inviting me on today and letting me blab on about what I think, which you'll still need $4 at Starbucks to get a cup of coffee with if you take my opinions down there.
Well, if people want to find out more about you, where can they go? Like if they want to check you out on Twitter or your website, where can people find you?
Sure. I'm on Twitter at Lester Tate, capital Lester, capital Tate. We've got a website. It's Akin, and you can Google Akin and Tate in Cartersville, although we have, sort of a statewide practice. And, I've got my email address and all that sort of stuff on there too. Also on Facebook, I get kidded because I've got almost 5,000 Facebook friends, but most of those are friends, clients, referring lawyers, people like that. You don't have to be my bosom buddy for me to let you follow me on Facebook if you want to do that.
Oh yeah, I've read comments on Facebook. You have friends on Facebook that run the full political spectrum.
Yes, yeah, I do, and it's kind of fun, actually, to see it on there. And that's the other thing. I feel like we've become very hardened in politics sometimes, and I'm unashamedly, a Democrat. But most of the people I represent are Republicans, mm-hmm. and there's no Democratic or Republican way to practice law, out there. And so I'm proud to have friends that are of different races, creeds, colors, different political beliefs, different religious beliefs. And I think that that's one thing that puts, that the court system is where folks come together, regardless of what their predilections are, to try to do right and do justice.
Well, I really, really appreciate it. Thank you so much.
Thank you, Scott.
Thanks for listening to The Advocate's Key. For more information and content like this, including a transcript of this episode, be sure to visit scottkeylaw.com, and please rate, review, and subscribe to this show wherever you get your audio content.